Now we're going to try this again. Sometimes it's extremely frustrating being a content creator because of moments like these where I just recorded an entire video and I hadn't had the article that I wanted you guys to follow along with me to pull it up. So we're going to try this again. For those of you who don't know, I am Dave, 10-year intellectual property attorney, dealing with everything from, as you can tell by the shirts, patents, copyrights, trademarks, as well as trade secrets. And I have a good one for you guys today. And this is based out of China, where the United States Patent and Trademark Office is looking to maybe cancel 40,000 plus trademarks that originated in China that were filed here in the US. And again, I would love to hear your guys' thoughts in the comment section, whether or not this is political motivated based on the new administration. And obviously at this point in time, the US, China, that relationship's a little bit on the ropes, or do you think this is a long time coming from the actual Chinese-based firms based on kind of what they were doing? Again, I would love to hear from you guys in the comment section. Another thing, please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community, where we talk about a number of things. We talk about these current events that, again, we're going to talk, which is the basis of the video today. We also, talk about Shark Tank breakdown videos every Friday, which they haven't done in a few weeks, but they are coming back up on Friday with another Shark Tank breakdown, Shark Tank video, and we break down those pitches. We also bring guests up. A lot of those guests are Shark Tank contestants and kind of talk about their journey, interview them on a one-on-one 40, 50-minute interview. They go through their story and kind of talk about their journey, as well as the importance of IP in that journey. And again, on the weekends, I do a live breaking down the IP lawsuit, as well as some weekly recap. So it's a little bit of everything going on this channel, and I'm pretty sure you guys will be able to kind of get down with something. So please hit that like button as well as the subscribe button. So let me kind of lay out the land on this issue before pulling up the article and kind of reading through it. It's a short article, so we won't be here long today. So typically, when you file for trademark applications in a foreign jurisdiction, you have to go through counsel in that jurisdiction. So, for example, if I have a client, and kind of we do this all the time on the patent side of things, if I had a client who's looking to file a patent or a trademark in China or Japan or Europe, countries in Europe, I would work with what we call a foreign associate or an attorney in that particular jurisdiction, foreign jurisdiction, and I will work with them to be able to kind of file for IP protection in that country. Now, thankfully, you don't have to jump through a ton of hoops to kind of get this done, whether it's copyrights, trademarks, patents. You can get it done relatively easily. Again, it may cost you some money, but it's not a lot of hoops that you have to jump through to get this done. And then vice versa. If you have a Chinese national or a Japanese national, and they wanted to file for trademark or patent protection here in the US, which again is the hot market, they wouldn't be able to do that themselves. They actually have to work with a US-based attorney to file that trademark or that patent application here in the US. So again, it's nothing new to be able to kind of file for trademark applications or IP protection in other countries. You just have to go through a firm in that particular country. So it seems like Shenzhen, which is a Chinese-based firm, for all the clients, companies, citizens who were in China, if they wanted to file in U.S., they were going through Shenzhen, and Shenzhen was essentially carrying out filing the trademark applications, or facilitating, I should say, filing the IP, or in this case, trademark applications here in the U.S. But again, Shenzhen still has to go through a U.S.-based attorney. Shenzhen can't do it themselves. So it seems like what was going on is, at least allegedly, based on the article that we're going to pull up, is Shenzhen was falsifying or committing fraud of these applications, 40,000+ trademark applications that they were filing in the U.S., and essentially entering in attorney information, U.S.-based attorney information, when they were filing it in the U.S. So for those of you who don't know, as an attorney, you get a P number. And in my case, as a patent attorney, I got a P number with the State Bar of Michigan, but I also have a registration number, a patent bar registration number, because I have to take the patent bar, which again, you see up there. So when I go to file for a trademark application here in the U.S., which again I've done on many occasions, I have to put my P number in and say that, hey, I'm an attorney in good standing with the state of Michigan before I file the trademark application. You have to do that with everybody. So again, Shenzhen, they would typically instruct a U.S.-based attorney to file the trademark application, in which the U.S.-based attorney will enter in their P number as well as their information when filing that trademark application. But it seems like what the USPTO is what they are accusing Shenzhen of doing, the Chinese-based firm, is entering in U.S.-based application or U.S.-based attorney information themselves and filing the trademarks, which again, they are, I guess one benefit of doing that, which although it's illegal, is you avoid having to pay the U.S. based attorney to do it. But again, like I said, it's still illegal, and it seems like they're kind of getting slapped on the hand, and they have 40,000+ trademarks that are on a chopping block essentially. So let's pull up the article, which I'm going to actually pull up this time. Thankfully, it's actually pulled. Let me go through it. So USPTO show cause order to cancel more than 40,000 China-originated trademark registrations. Shenzhen response. So again, Shenzhen is the Chinese-based firm that appears to have been kind of doing some illegal activity. In a February 24th, 2024 show cause order, so this was just last month or maybe a week or so ago, again, Shenzhen, the USPTO announced that about 42,000 trademark registration decisions might be vacated in the application or post-proceeding registration proceedings reopened for a new determination to be made. For an initial registration decision, the registration will be canceled and restored to pendency under its application serial number. The reopened proceeding is a proceeding that may be subject to termination. So what does this mean? They're essentially saying, hey, we have from Shenzhen, and I would imagine that this took place over the course of years. I'm pretty sure Shenzhen didn't file 40+ thousand or 42,000 trademark applications in 1 year. But they're saying, hey, we're going to cancel these registered trademarks so that their status goes back to pending as opposed to registered. And some of those pending applications may be later canceled. So it seems like they're giving an opportunity to for Shenzhen to be able to kind of not have to go through this process. But to the extent that Shenzhen doesn't provide the necessary information, these applications will not be registered anymore. They would actually be pending, and then some of those pending applications may be terminated or canceled later down the line. So let me pull this back up, make sure I have it back up. The USPTO states the integrity of the USPTO examination and decision-making process were tainted at their core, and the USPTO's registration decisions were premised on false representations and assumptions. This show cause order supplements two prior show cause orders stated September of 2022 and the end of 2023. So it seems like this Shenzhen company and the USPTO has gone back and forth a few times. In the first show cause order, the USPTO stated that seller growth practice unauthorized practice before the USPTO in trademark matters and providing false, fictitious, and fraudulent information in trademark submissions with the intent to circumvent these rules. The USPTO also stated that the evidence indicates that the respondents are not qualified practitioners under essentially a federal law, yet still engaged in an unauthorized practice of law through the use of names and bar credentials of U.S. law attorneys, licensed attorneys, intentionally providing for the purpose of concealing respondents' involvement in circumventing USPTO rules. Further, respondents' efforts to mask their participation in the unauthorized practice of law include improperly entering the electronic signatures of at least 3 U.S. licensed attorneys and providing false, fictitious, and fraudulent attorney information and trademark filings in violation of USPTO rules. Hey, look, I can tell you what, that's a big deal. Number one, because like I said before, you have to work with the U.S.-based attorneys to kind of file trademark and patent applications here in the U.S. And if I'm a U.S. attorney, which I am, or other U.S. attorneys, they're probably going to be skeptical to work with this Shenzhen firm in China if they're doing this fraudulent information. If I know a firm is kind of been accused or engaging in fraud, I'm going to kind of be skeptical or hesitant to work with that attorney for any matter. So this can kind of really hurt Shenzhen if these allegations are meant to be true. It seems like, in my opinion, or at least kind of according to the article, this may not have been based on the new administration. It seems like the USPTO kind of have been slapping Shenzhen on the wrist back in 2022 as well as the end of 2023. And at this point, it seems like they got fed up in 2025 saying, hey, come and explain to us why we shouldn't cancel these marks or why you haven't engaged in fraudulent, fictitious activity. And to the extent that they can't show that, seems like a ton of citizens of China as well as companies in China may kind of be out of a trademark. So again, hopefully you guys got something out of that. Like I said before, I would love to get your guys' thoughts on it. Yeah, we're not talking about 1 or 2 trademark applications, 42,000 trademark applications that are from Chinese companies or citizens are on a chopping block because of maybe some fraud of these Chinese-based firms. Now, like I said, I'm interested in knowing from you guys or hearing from you guys, do you think, yeah, they've been kind of back and forth with the USPTO for a number of years, but this new administration kind of pushed for this, given that our relationship with China is on the ropes? Or do you think, hey, Shenzhen and kind of all the stuff that they were engaged in, they kind of had this one coming. This had nothing to do with the new administration. So let me know what you guys think in the comment section. Hopefully you guys enjoyed this video. Hopefully I recorded it the right time this time. And again, please hit the like button for the algorithm, as well as hit the subscribe button to be a part of the IP community. I will check you guys out on the next one. Peace.